we're done in this section.
So you're still hacking squirting?
Not in this area.
But you're still doing it in the county? After 62% of the people voted against it?
Wait, let him answer the question. Are you still doing hack and squirting, John?
Yes, we are.
That's terrible.
So if we want to get on that topic, we can. That's not associated with this plan because we have,
But it's in our county.
it's in our county, so if we want to go there, that's fine.
I don't want you guys to do it.
Mendocino Redwood Company's John Anderson asserts that the California State Right to Farm Act takes a precedence over the recently passed voter initiative Measure V.
You said that treating Tanoc and leaving them standing are considered a public nuisance. So we said, okay, we really got to study public nuisances. And we found that at the state level, they had really, back in the early 80s, had thought that there's a lot of encroachment on farmlands and on forestry from urbanization moving closer and closer, and there was starting to be a lot of pressures on them, and so they passed a Right to Farm Act that said you cannot deem agricultural operations a public nuisance if it's been going on for 3 years and it has not been deemed a public nuisance in that time. And it goes on further to define agricultural operations as forestry and modifying stocking in the forest. And it says no county or city can pass an ordinance to go against the Right to Farm Act. So we said, okay, that's what the state says. What does our county say? The county copied that same language and put it in the county code, and further stated a paragraph that said the Board of Supervisors shall uphold this, and no future ordinance shall be passed that goes against this, otherwise it shall be considered immediately repealed.
That's handy.
But this happened long before MRC came along, okay?
Yeah, but that rule would preclude you from using hack and squirt on any new timber operations.
Well,
wouldn't it?
It's we've been doing it on our ownership for 15 years.
But you're saying within a 3-year period. So what about now in the next 3 years?
Yeah, you know, I think we're getting into a lawyer interpretation of that. Yeah.
But it should preclude you.
Yeah, well, so we checked with attorneys outside of our company, not ones we pay. You know, we have one in-house attorney, but we didn't want to use him, even though we think he'd give us an unbiased opinion, but we just wanted, from a public perspective, to say, hey, let's bring someone else in. Their interpretation was that we are exempt from it based on these rules for our ownership. And so we sent a letter to the county spelling all this out and said, if your interpretation is different, please let us know. We gave that letter to the county July 6th, and we've had no response. So, yes.
It is law. This Measure V is law now, and you are not obeying the law. It's not up to the Board of Supervisors to decide whether it's legal or not. It's already been decided, and it is law. So you either have to challenge this law or obey it, and you're not doing either, as far as I know.
Well, the county says
you're not obeying it for sure.
The part of the county code that said it'll be well, let me finish the sentence. The county code that they passed back in the 80s said that any future ordinance that considers agricultural operations a public nuisance shall be considered immediately repealed. So, you know, it seems like I really wish the county, before all these signatures were gathered, looked at the language and said, boy, in our own county code, we can't do this.
But you guys didn't know that either, right? Because you wouldn't have paid $200,000 on your campaign against it, right?
Yeah, I believe it was after that. Don't quote me on the exact timing of the campaign and all that, but
it's too late.
Yeah. So, anyways, but Tanoc treatment's not occurring here. We agreed with the Albion community to only use chainsaws and do that experiment that we talked about.
Thanks, Linda.